So the next panel is on why does it happen, how does it happen, what are the causes of wrongful conviction? And I'm going to introduce our panelists. First, we have Becca Brown. She's been with the Innocence Project, the mothership in New York, for 13 years and directs its federal and state policy agenda in collaboration with Innocence partner organizations around the country. Her team and the network have passed more than 150 pieces of innocence-related laws in the past decade, including Senate Bill 77, which Governor Strickland signed into law here in 2010. Rebecca was instrumental working with us in Ohio in order to help get that law passed. Next is Carmen Naso, second to the end. Started his career as a prosecutor. He was there as a prosecutor's office here in Cuyahoga County for 4 years. Spent 20 years as a criminal defense attorney, then returned to the prosecutor's office for 7 years, then left in 2008 to teach at Case Western Law School. And he has a post-conviction clinic here, as you've heard, and teaches courses on wrongful convictions. So he's been on both sides of the courtroom on this issue. We have Bill Brooks, who's next to Rebecca, is the chief of the Norwood, Massachusetts Police Department, has been a police officer for 41 years. He was a 2012 recipient of the Innocence Network's Champion of Justice Award and received the Civil Rights Award for Individual Achievement from the International Association of Chiefs of Police in 2015. He speaks nationally on eyewitness identification on behalf of the Innocence Project and served on the committee at the National Academy of Sciences that issued the 2014 report identifying the culprit, assessing eyewitness identification. Chief Brooks sits on the board of directors of the International Association of Chiefs of Police and is a graduate of the FBI National Academy. And finally, on the end is Russell Tye. He's currently the co-criminal chief of the Cuyahoga County Prosecutor's Office. As criminal chief of the Major Trial Unit, he supervises the Major Trial Unit, which includes cases involving Cuyahoga County's most serious felonies, from death penalty cases, aggravated murder, sexual assault, child cases, adult and elderly victims. He began his public service commitment as an assistant prosecuting attorney in Lake County, Ohio in the mid-90s and remained there for just over 4 years. For the next 16 and a half years, he was in the private sector as a defense attorney, criminal defense attorney, and general practitioner. Over the past 20-plus years, Mr. Tye has dedicated himself as a trial lawyer. He's tried many cases in state and federal courts in Ohio and beyond. In January of 2017, he joined the Cuyahoga County Prosecutor's Office as chief of the newly created Civil Rights Unit. Although the Conviction Integrity Unit was originally created in 2014, this unit is now a division of the Civil Rights Unit under Mr. Tye's direct supervision. He brings his diverse background and relentless passion for justice as he supervises the CIU and ensures that every qualifying petition brought before the CIU is fairly and carefully reviewed and investigated. So the panel, we discussed this week how we're going to do this and what topics we're going to discuss. And we're going to start off with Becca Brown, who's going to give an overview and talk about some of the initial issues of wrongful convictions and how they happen.
Great. Thanks, Mark. And thanks so much for having me today. It's really an honor and pleasure to be here with all of you. So, you know, the beauty of really working on system change in the policy realm rather than litigating claims of innocence, besides not having to take the bar exam, is that it really allows us to kind of remove our adversarial hats and really work together on system change that really benefits the entire public good. And you know, I think it's just worth noting that no one benefits from a wrongful conviction, but except for possibly the actual perpetrator of the crime. It harms the police, it harms prosecutors, it harms the victims of crime, and it certainly harms the innocent. And at the Innocence Project, we've actually begun to collect data related to the nation's DNA-based exonerations. There are now 363 DNA-based exonerations around the country. And we've begun to collect data around real crimes committed by the actual perpetrators while the innocent languish behind bars. And the numbers are striking. So we've identified the real perpetrators of crime in about half of our cases now, half of the 363 cases. And while the innocent were behind bars, actually doing time for their crimes, those actual perpetrators went on to commit more than 80 rapes and 40 murders. And those are just convictions. I don't have to tell people in this room that that probably doesn't begin to represent the scope of criminal activity that those people were up to. So I think it's just really worth pointing out that obviously any policy reform that we put in place to prevent wrongful conviction, you know, has the added benefit of really benefiting the public safety. And so I'm really here to describe, and this will be a very brief overview, and other folks on the panel will go into finer detail, but really how wrongful convictions happen. I'm going to just touch on some of the key contributing factors, share some basic data with you about what we know about the nation's DNA-based exonerations and also non-DNA exonerations. There's a database actually maintained called the National Registry of Exonerations that combines data for non-DNA and DNA cases. The National Innocence Project separately maintains a database for all of the nation's DNA-based exonerations. So I'll be providing data for both of those data sets today. And I also do want to stress that, in many ways, it really isn't official misconduct that's touching many of these cases. It really is a question of human factors that are touching these cases, and often these are human factors that are working in combination. And I'm often really struck by the fact that when you look at a lot of wrongful conviction cases, it looks like a mountain of evidence that helped to convict a person. And ultimately, when that case is unpacked, it is more like a house of cards, but it's understandable when you look at the case that there seem to be so many pieces of evidence that point to guilt. So just basic numbers, there are more than 2,200 exonerations across the country now, close to 2,300. Those are both DNA and non-DNA, and that's according to the National Registry of Exonerations. Again, 363 of those are DNA-based. And when I kind of talk about the causes, and I'm going to give you some of the figures in a moment, you're going to hear some real differences between the non-DNA and DNA numbers. And that's because there are different patterns based on the kinds of crimes that we're talking about. So for instance, we know that jailhouse informants are really much more prevalent as the crime becomes more serious, which is an interesting trend that we see in a lot of our cases. So I'll run through the contributing factors and then just really do a flyover of some of the reforms that we're seeking in some of these areas. So the single largest cause of wrongful conviction in the DNA database set is really eyewitness misidentification. So we know that 254 of the nation's 363 DNA-based exonerees involved eyewitness misidentification, so that's nearly 70% of those cases. When you look at DNA and non-DNA cases together, it's about 30%. And that's really, again, because a lot of those crimes are not going to even involve eyewitness identification, drug crimes, those kinds of things. So that's why you're seeing a large reduction. But when you look at crimes like rape cases, which are a lot of the DNA cases, there's a lot of eyewitness ID cases, and that's why the numbers are so high. 104 of the DNA-based cases involved a false confession. So that's about 30% of our cases. And this is a trend that we're really seeing more and more in our cases, just that a lot of innocent people do, in fact, either plead guilty or confess to crimes they didn't commit. And while it's counterintuitive, I think, for a lot of people, we're seeing it quite a bit. 11% of the nation's DNA-based exonerees pled guilty to rape or murder. So it's quite a compelling figure. And 12% of the DNA and non-DNA cases together involved a false confession. Government misconduct is present in about 15% of the nation's DNA exonerations, 52% of the DNA and non-DNA together. Again, government misconduct can be any state actor. It can involve crime labs. It can involve prosecutors' offices. So this is not simply one actor. Inadequate defense is present in a quarter of the nation's non-DNA and DNA exoneration cases. Informants, 17% of the DNA-based exonerations involved informants. That number is much lower when you account for non-DNA cases as well. That's down to 7%. So again, as I mentioned before, as the severity of the crime increases, we see more and more jailhouse informants present in cases. And forensics is a huge cause of wrongful conviction. About half of the nation's DNA-based exonerations involve some sort of misapplication of forensic science, and 547 of the 2,300 DNA plus non-DNA cases involved the misapplication of forensics. So just in terms of some of the reforms that the Innocence Project works on and often works on in collaboration with law enforcement partners around the country, really touch on I'll just talk about some of the police practices. Eyewitness misidentification. We work on really what we call the core 4 reforms. Ohio does have a law that embraces these reforms, and they include blind administration, instructing the witness that the perpetrator may or may not be present in the lineup, taking a statement of confidence at the time of the identification, and making sure that the lineup itself is fairly composed so that no one stands out, and so that all of the lineup members really match the description that the eyewitness presented. So we're working in that area, and we've really seen incredible change throughout the country in this area. I think when I started about 10 years ago, I think only about 5 states had embraced these reforms, and we're now up to 22 states. Just a month ago, California passed a comprehensive law in this area. So it's really been major change around the country that we're thrilled to see. Also in the area of confessions, recording custodial interrogations is the single most important reform we can put in place, because when we're looking back at these old cases, we can unpack what happened in the interrogation room. It's the single best reform to give us a sense of what transpired. And again, when we talk about, the fact that in many of these instances, this isn't about someone intentionally doing the wrong thing, being able to look at a videotape and seeing what might have gone wrong isn't about finger pointing. It's often about just identifying what happened. We work very closely with a police chief, or a retired police chief from DC, who you're going to see a video of shortly, who talks and recounts the fact that he took a false confession in a case totally unknowingly, from a woman who, confessed to the crime, and when he went to check her alibi, found out that there was no way she could have committed the crime at the time that the crime took place. And when he reviewed the tape, he saw that he had unintentionally fed facts to her during the course of the interrogation. Had no idea that it had happened. It was, a human factor that impacted that investigation. And so recording the interrogation is probably the single most important reform we can put in place in this area. And on Jailhouse Informants, we're working very closely on really making sure that we're tracking these informants, that we have a good understanding of their criminal history, how many other cases they testified in, what was promised to them, what they received in exchange for their testimony, and just making sure that information is available to both parties. Because, there are instances where we have seen informants go from county to county, and none of the counties are aware that this is, what's happening. And so we're really looking for the creation of tracking systems. Tarrant County, Texas, for instance, has a marvelous tracking policy, and that really served as the basis for a statewide law in Texas to regulate jailhouse informants. And so there's a lot of movement afoot around the country. And, the other thing that I'll just stress is that, one of the things that we're really beginning to focus on, and we did this recently in partnership with the Ohio Innocence Project, is really the human factors that affect criminal investigations, really things that are in many ways out of our control, but can be reformed. And we're going to look at a couple of videos around that, but I'm going to just touch on what those are. Confirmation bias, so really, how people tend to interpret evidence in a way that confirms their assumptions or preconceptions. Memory malleability, so sort of how memory is constructed and how it's susceptible to being manipulated by, false information. Eyewitness misidentification, we spend a lot of time thinking about sort of how memories are constructed and how people retrieve those memories. False confessions, so sort of how interrogation techniques can yield false confessions. The presence of deception during an interrogation has really been shown to be, a huge cause of wrongful conviction and false confessions. Lie detection and demeanor evidence really exposes the myth that it's not possible to tell whether or not someone is being truthful from their physical tics or from their mannerisms. We did a short piece on tunnel vision as well. It explains the harm of focusing on a single or limited theory, police or prosecutorial theory, seeking only evidence that confirms that theory, very much a human factor in investigations. And finally, implicit bias, how personal experiences shape our views and can result in unintentional bias that can affect criminal investigations. So we were really proud to work with the Ohio Innocence Project on this, and even more excited when the International Association of Chiefs of Police joined with us in really pushing out these videos around the country. It was a collaborative effort, and we were just really thrilled to partner with the police on this very important project. So we're going to show a couple of those videos, which will be, I think, a nice lead-in to Chief Brooks' presentation, and those videos are going to focus on eyewitness misidentification and false confessions. Thanks.
Nobody believes they would ever confess to a crime they didn't commit. And that's an important starting point, because to confess to a crime you didn't commit is to put yourself in jeopardy of incarceration. It's not something people do. And so when somebody confesses to a crime, everybody, cops, prosecutors, judges, juries, everybody believes that confession. The psychology underlying the study of false confessions is really two psychologies. Why does it happen? And when it happens, why does everybody believe it? Everybody, I think, fundamentally understands that they have a breaking point. Whatever the story is, if stress levels have built, if the suspect starts to think, and this, again, tends to happen over a period of time, that it's in my better interest to confess than to continue deny involvement, in that case, what happens is an innocent person succumbs to the pressure and agrees to confess. Now, that's an interesting phenomenon because it is a transient confession. It happens momentarily. And as soon as the pressure of the moment is lifted, as soon as a lawyer comes into the situation, immediately there is a recantation. The suspect recants the confession. I was under pressure, I felt coerced, I didn't do this. That's the hallmark of a compliant false confession. As an act of compliance, they agreed to confess, but privately they knew they never did this, and that was the end of that. That, I think, people fundamentally understand. Situations like sleep deprivation, threats made or implied, promises made or implied, can alter the mental calculation of a suspect under stress to make them think that it's their best interest to confess at this point. And the interrogation tactic in particular that puts them at risk for that to happen is lying about evidence. In the United States, police are allowed to outright lie. They're allowed to say to a suspect, we had DNA found on the victim and we tested it and it's yours. Or we found hair within the victim's grasp. We tested it. That was your hair. Or we found the victim's blood on your pillow. Or that polygraph that you agreed to take, you failed it. Now, if you take somebody who's vulnerable to manipulation and their grasp on reality is starting to weaken, and you outright lie about the evidence, you can shake in their view of reality. So when you look at confession evidence, you have to ask yourself what risk factors were present in the person that made him vulnerable, what interrogation tactics were used that would make anybody vulnerable, and there's a good 100+ years of psychology research showing that when you lie to people about reality, when you misrepresent reality, you can produce profound changes in people's visual perceptions, beliefs, autobiographical memories. The problem is 95% of false confessions contain accurate details about the crime that were not in the public domain. When you have a conversation with somebody, when you interrogate somebody, as part of that process of exchange, you're not just eliciting information, you're communicating information. So if a suspect is broken down to the point where the suspect believes it's in his best interest to confess, he probably has received through the process of interrogation enough facts to make that confession credible. I defy any prosecutor or judge or jury or appeals court to get past that statement. It's almost not possible. I've looked at confessions that have proved to be false before I knew they were false, and I believed them. And I'm a critic of confession evidence, but I believed them. And so that is essentially the problem of how you get people to recognize it. That begs now the question, how do you solve this problem? How do you solve a problem both that the false confession happens and that people can't tell a false confession if they see one? An interrogation needs to be recorded from start to finish. Whether you call it an interview or an interrogation, the entire process from start to finish. It will make police better at what they do. It will make suspects more likely to It may not make guilty suspects more likely to confess, but I think it might make innocent suspects less likely to confess. And then it will make better fact finders of prosecutors, judges, juries, and appeals courts.
Many people probably believe if you saw an individual who committed a crime, you probably never forget that face and you would be accurate in your identification. But we know from real cases that eyewitnesses routinely make errors in their identification decisions. Human memory is quite malleable. Take a moment to think about a day and moment in your life. Think about what you can actually see in that memory. Do you see yourself from a third-party perspective, like a video camera exploring the event? If that's the case, this is not a real memory. Your memory has been contaminated over time, probably from photographs or videos, or maybe even talking to other people. It could also be your imagination. At the end of the day, this type of contamination is not a problem for most people because it's happy. But for eyewitnesses to a crime, this can be extremely detrimental for an innocent suspect. We assume that if a witness says, "I'm absolutely certain that's the person," then that witness must also be accurate. But our research shows that that's not entirely true. And as you can imagine, in circumstances where perpetrators carry a weapon, such as a gun, it automatically increases a witness's level of stress and fear. Witnesses tend to focus on the weapon that they're being threatened with. And when they do this, they're not able to focus, pay attention to, perceive other aspects in their environment. There's nothing law enforcement can do to improve or increase that witness's memory. But we know that law enforcement can actually do things to increase the likelihood of an accurate identification. And these are, in effect, the choices that law enforcement make during an investigation about how to collect the evidence, how to test a witness's memory accurately. When eyewitnesses and victims in these types of cases make an identification error and pick an innocent person, these are not intentional, malevolent identification decisions. These are witnesses who genuinely believe that the person they picked is the actual perpetrator. The problem is they're mistaken, and it's very difficult for law enforcement, judges, jurors, and others to tell when an eyewitness has been accurate or inaccurate in their identification decision. We know that we cannot prevent all mistaken identifications from eyewitnesses, but we know that we can reduce the likelihood that those types of errors will happen. And we can do this by following best practices. Double-blind administration is recommended, not because we don't trust law enforcement, but because they're human beings. And at the end of the day, we tend to see what it is that we want to see. The FDA, for example, requires double-blind administration in their drug trials. And it's not because we don't trust doctors and nurses to run those trials accurately. It's because they can be influenced by their expectations and what it is that they want to be in terms of the outcome. Law enforcement are the same. And so double-blind administration protects the witness and protects law enforcement from any accusations that there was influence in the outcome. At the end, we need to make sure that the witness's level of confidence, or how certain they are in their identification, is accurately recorded immediately after they make the identification decision. Because many actors in the criminal justice system rely on that witness's statement of confidence to try to figure out if the witness was accurate. Over time, if a witness is told information and given updates about the case, what we know now from research is that the witness is likely to become more and more confident about their identification, so that by the time the witness testifies at trial, any statement of confidence that the witness has currently about their identification decision is really quite irrelevant in helping us try to figure out if that witness was actually correct.
With the endorsement of the International Association of the Chiefs of Police, who will be using them in training, we're hopeful that these will proliferate and that prosecutor's office, police departments, and everybody in the criminal justice system will start using these to start understanding that wrongful convictions 95% of the time or more don't happen because somebody was intentionally doing something wrong. It's because our system is not recognizing some of the problems that humans have in processing information, and we don't have the proper procedures in place to eliminate or at least mitigate human error. So next we have Bill Brooks.
Yes, and I think Mark makes a good point that, once these videos distributed through IACP, we have 31,000 members worldwide in 150 countries, most of them here in the U.S. And that if each of those chiefs then show these videos in their departments, they can really have a tremendous amount of impact. And also to follow up on what's already been said several times now is that we're not talking primarily about misconduct, but eyewitnesses have a genuinely difficult time with this kind of evidence. And it's a little odd, and unlike other evidence, we're relying on the eyewitness's recollection of the offender's face. And we can't see that recollection. We can't measure it in any way. So essentially, we're providing that witness with a stimulus and asking them to make a match. So it might be a live person on a show-up, or it might be one of the photographs in an array, and we're asking them then to match their memory to that stimulus. And it's a very difficult process. We're not talking about recognizing somebody that the witness is familiar with. We're talking about the witness seeing a stranger, and sometimes a week or two later, being able to pick out a mugshot or a driver's license photo. So it's a very difficult task and a difficult process. When I talk to police chiefs around the country, and I do that quite a bit, and the Innocence Project sends me around a little bit, as Mark has already mentioned. But I start off by telling police chiefs that this is kind of your classic low-frequency, high-risk event in law enforcement. I've always said that eyewitness identification probably only exists in 2% of criminal investigations, and now there's a study that says 3%. But most crime is unwitnessed property crime, and most violent crime occurs among people who know each other. There's only a slim margin of cases, and now they say 3%, where we rely chiefly on the recollections of an eyewitness of the offender's face and ask them to make that memory to stimulus match to tell us whether or not we've got the right person. So if it's only in 3% of criminal investigations, yet it's represented at close to 70% of wrongful convictions. Low frequency, high risk. It doesn't happen in most cases, but it's a risky event when it actually does. So it's something I think for police to think a little bit about. And as a result, anytime you have in law enforcement, whether it's use of deadly force or high-speed pursuit or hostage taking or anything like that, that's low frequency, something that doesn't happen all the time, but the stakes are very high, you have to train around it a lot because you can't wait until the event occurs to do the training then. It's too late. So I think that the drivers behind how we make some of these changes around the U.S., and Rebecca is right, we're seeing widespread changes around the United States for a number of different reasons, most chiefly, quite frankly, because of the work of the Innocence Project, bringing this to the attention of the police and working so closely with the police. But I think you are seeing a lot of developments, and in two overarching areas. One that gets talked about a lot is policy, for departments to adopt written policies in eyewitness identification. It's been mentioned, I'm on the board at IACP. We have a model policy. We're actually in the second iteration of that policy that was just updated a year or so ago. The Innocence Project provides toolkits to any police department that asks for it, that has a number of model policies in it. Metropolitan Police in Washington, D.C. is one. My department is one of them as well, but there's a number of model policies, including the IACP policy that you can choose from. But the other big part of this is training. And the training part really makes the police aware of the risks and pitfalls around eyewitness evidence. As has been mentioned, I sat on the National Academy of Sciences committee that generated the report in 2014, and there were only 5 recommendations for the police, and number 1 was train your officers. Train people. You can't just hand people. When you went to law school, they didn't teach you cross-examination by handing you a policy on the confines of cross-examination. Presumably, they trained you on it. And it's the same thing with the work that we do. You have to be trained in it. And when you train people, you get better decision-making. I see now officers on my department and on other departments making better decisions in eyewitness memory cases. It used to be that if you had an eyewitness who saw the offender and you had a suspect, you showed a photo array. Now, departments that have been through this training are much more conservative in that way. I have a friend at the Charlotte-Mecklenburg Police Department, as does Rebecca, and I heard him speak recently, Major Mike Smathers, and he used to run the robbery squad, and I think he said that in 70-something% of their robbery investigations, they used to show a photo array, and now they've brought that down to, I think it's less than 10%, by using other kinds of evidence and trying to show that the defendant was involved in other ways. You only show a photo array when you really have to, and there's no way around it, as opposed to it being kind of default position. So, and that comes from training and awareness, which is a big part of this. As far as what Rebecca mentioned as the core four, and then you saw Jen Dysart talk about it in the video. So blind administration, which I think everybody understands, essentially means that the officer showing the photo array is unable to tell when the witness is seeing the suspect. There's two ways to do it. One is the double-blind method that she described, where you use an officer who's unfamiliar with the case. On my department, detectives never show photo arrays, ever. We call a radio car in off the street, hand him the photos. He sits down with the witness. The detective explains what's going to happen and reads through the instructions. Then the detective leaves the room. A patrol officer, completely removed from the case, shows the photographs one at a time, takes the identification, takes the confidence statement, I'll talk about that in a minute, and then calls the detective back in. At that point, we send the witness home. We don't even discuss what's occurred in front of the witness. The detective watches the videotape of what occurred. He assesses where it fits in his case. The officer in the room with the witness is completely removed from the case. There's also another method of doing this, a blinded procedure, where you essentially put the photographs in separate folders and you hand them to the witness to your left, and when the witness opens the packet, you can't see which photograph she's looking at. And that's a blinded procedure where you can be there for your own photo array. It's good for small departments. It's good where virtually everybody in the police department knows that particular suspect. It's got a number of applications, but 99% of the time when we show a photo array, it's shown by a uniformed patrol officer that's called in from the field. I mentioned reading scripted instructions to a witness. The big instruction that I think is the most important that you hear over and over is that the offender may or may not be in this photo array. We actually read a 12-point instruction page that also says that whether or not you make a selection, we'll continue to investigate this case. With this process, it's just as important to clear innocent suspects as it is to identify those who are guilty. It asks witnesses not to discuss the case with the media or other witnesses, and there's about a 12-point instruction that's read. We do that, not only a scripted instruction page from a photo array, but our officers carry a laminated card in their pocket for show-ups, and it's also on the back cover of our department notebook. So when they're out in the field, if they have to do a show-up, they read those instructions. It allows us to memorialize exactly what the witness was told, and that's then turned over to the defense and can be used by the court in considering motions to suppress and the weight of evidence and so forth. And then lastly, the statement of the confidence statement, and this is something that you heard Jen talk about as well, that the day will come when a witness will not be permitted to take the stand, identify the defendant, and then tell the jury how certain she is. The only certainty statement that will really matter, and quite frankly, the only one that matters now, is what she told the cop when she saw the photo the first time. And that we're showing a photo array, and the witness stops you at number 6 and says, "That's him." Our officer, and it's on the bottom of the instruction page, he immediately asks, without using a numeric scale, "Tell me how certain you are." And we video record the showing of every photo array, and that video is then provided to the court. Everybody knows what happened in the room, and when you got a witness who stops you right in your tracks, says, "Wait, right there, that's the guy." Research has shown that rapid memory tends to be more accurate than the people who give it too much thought. Recognition memory is not thought, it's recognition. It functions more quickly. And when you get a highly confident witness who reacts quickly and you've used the proper procedures, that does carry some weight. It carries some weight as far as accuracy. And the day will come when the detective will get on the stand and talk about how certain the witness was 8 months ago when she first saw the photograph, and the witness won't testify from the stand live about how certain she is today, because as Jen said, quite frankly, frankly, it's not relevant. It has no attachment to the likelihood that that's actually the offender. There's some other things that the police look at, too, that are outside kind of the core four that you've heard about. I'll just mention a few. It's in our department policy. It's also in the trainings that we do. The avoidance of successive identification attempts, that once you've exposed a witness to a suspect, that witness never sees that suspect again. It is what it is. You get an identification or you don't, but you never show that witness, that suspect again. A few years ago, we had a bank robbery. The guy was unmasked. He slid a note to the teller. Make a long story short, a suspect was stopped 15, 20 minutes later or so. They brought the teller out to where the suspect was stopped, and she kind of looked at him and hemmed and hawed and kind of rubbed her eyes and looked away and then looked back at him. So right away, that's not good. When you come around the corner and she says, "Oh, you got the guy, nice job," that's a good show up. But when she sits and stares and looks away and then goes back. So anyway, she didn't make a selection, and an officer asked me later, "Now we're going to put him in a photo array." And I took a breath to answer the question because there was so much I wanted to say. And before I did, he says, "I bet she'll pick him." I said, "I know she'll pick him. I don't know if he robbed the bank," because his face will jump out of that photo array, aside from all of the other fillers, because the recognition she'll draw will be from the show-up, not from the robbery. And there's no way for us to tell which is which. So at my department and departments that have adopted these reforms, you show a suspect to a witness once and that's it. Like it or not, now, regardless of how you make out, there's only one exposure. My department doesn't do composites. We haven't done composites in over 10 years. There's research that shows it actually skews the memory, that witnesses walk away with an impression of how the composite came out as being the way that the offender looks, when in reality that's not the case. And in that particular research, witnesses who helped the police with a composite actually had lower accuracy rates than witnesses who had not done composites. So in any event, those are, and there's more to it than we have time to talk about now. But really thanks to the work of the Innocence Project, quite frankly, and not only working with state legislatures, but working closely with the police. I've had the opportunity to help with a little bit of that. Yeah, you do see these reforms taking place through both policy and training across the U.S.
We try to observe what's going on the outside to get to what is going on the inside. People often overestimate their skill at reading other people's mind. It's quite difficult actually to get to another person's inner states. The leakage hypothesis has been around for a long time, and the idea is that liars will leak different cues, so to speak, than truth tellers. The idea with micro-expressions falls under the leakage hypothesis. Micro-expressions are expressions that are shown for fractions of a second in the facial muscles. That has scientific support. But the problem with this is that liars and truth tellers, they both show micro-expressions. And there's no micro-expressions that only liars show and no truth teller. So this is a problem with the idea of using micro-expressions to detect deceit. When you use these nonverbal cues, you perform just a bit better than chance level, 54%, and chance level is 50%. We also know from research that this also holds for police officers. They don't perform better. The only difference between police officers and others that have been studied is that police officers are more confident that they are accurate. So this is a dangerous combination, having poor accuracy but high confidence. One source of being highly confident is that you think that you have used reliable cues. You think that, well, I have used the cues I've been taught, and therefore I'm absolutely certain that this person is lying or telling the truth. People tend to use nonverbal cues, gaze or fidgeting and so on. But what research shows is that there are no associations between fidgeting, eye contact, nervousness, and deception. Within the scientific community, there's no debate about this. the read technique is very problematic, and especially when it comes to the guidance that the technique gives for detecting deceit. One argument that comes up is that others might go wrong, but I know which specific nonverbal cues that work. But the problem with that argument is that there are no reliable nonverbal cues. The second argument is that, well, I don't look at one nonverbal cue, I look at many at the same time. But the problem is that if there are no reliable nonverbal cues, it doesn't matter if you use one or if you use many. So today we can see a shift of paradigm that goes from the nonverbal approach and the emotional approach, which is about trying to read a person's inner mental states by observing behavior, to the cognitive approach. What you should do is to go for speech content. You can look for inconsistencies. It can be an inconsistency between what you know and the person is telling you. Use the background information that you have as an interrogator in an optimal way. You can look whether the person is telling things that can be verified or not, because a person can talk a lot, but he or she doesn't say anything that can be verified. You should also ask unanticipated questions or ask the suspect to respond in a format that is not anticipated. For example, to draw a sketch instead of verbally answering a question. That's the way forward for lie detection.
In one of our Innocence Project cases where the person was exonerated by DNA testing, in the civil suit that followed, the detective who investigated the case was on the stand and on cross-examination actually said, I focused on him because I can tell within a minute or two whether the person's telling the truth or not with 100% accuracy. And I could tell within a couple of minutes that this person was lying. And this was in 2013, gave this testimony. And then once that decision is made, this person's been taught by the read technique that these nonverbal cues and these micro expressions are actually accurate ways of telling the truth. But once that decision is made, confirmation bias, tunnel vision, everything kicks in, and then you just start rolling down this path where the investigation goes awry. So next we have Carmen Naso.
Thanks, Mark. I wish I would have had that lie detection video when my mother was busting me as I was growing up. My role here is to discuss the culture of the prosecutor's office, and I don't mean the Cuyahoga County Prosecutor's Office, but I do have some experience with it because that's where I started my career. And I think this is one of the most difficult discussions to have, and I applaud the Chief Justice when she said we need to have the courage to have honest discussions, because reflection on how we operate a prosecutor's office is good, and sometimes we see that the policies we have created, even though they were the best intentioned, are just not working like they were supposed to. Among the things I would like to mention is that the vast majority of cases that are prosecuted are not murders and sex offenses, but I believe all the exonerees in Ohio were either homicides or sex offenses. Is that? Okay, robberies. And the reason I say that is because a conviction for a robbery can get you 15 years if you use a firearm. So they're not just very high-profile cases. Many of these cases are the ones that are handled by young prosecutors, for example, and it's important that we examine and consistently look at what the message we're sending to them and what we're teaching them too. The culture of a prosecutor's office is a character asset. It's different than the morale of the office. The morale is a subset. The culture is the defining principle of a prosecutor's office. And my perspective starts 40 years ago. I was assistant county prosecutor. I was 26 years old. I was in an office filled with people who were very young. and I came there to learn trial skills. The business model back then was to pay very little. And the object was the prosecutor's office would give us opportunities to learn skills that then we could take out into the marketplace and begin our legal careers and take care of and raise families and live comfortably, I guess. Back in 1979, there was no open discovery in Cuyahoga County, and so it was left up to us to decide what information a defense attorney was going to learn in an attempt to defend their client. I had no appreciation for or perspective on what would be considered exculpatory evidence. Nobody trained me on it. When I was a young prosecutor, when they handed me a file, it was unstated, but the directive was to go win the case. The philosophy then, and it was told to me in these terms, if they're for it, we're against it. I wasn't to be concerned about convictions because that's why they created the Court of Appeals. A friend of mine who is a judge and I were discussing this, and we were discussing my work with the Innocence Project and wrongful convictions, and that judge called it a pretty reckless way to get to the truth. I went out for 20 years and defended people who were accused of these crimes, and I came back to the prosecutor's office in 2001, and at that time I came back to an office that had changed greatly. And doing the right thing was given a much higher priority than what I believed to be my job, which was earlier to get convictions. But even then, in 2000, there were some practices that were undertaken that we should be critical of today. In no way is what I have to say today informed by the practices of our county prosecutor's office today. It's what I've learned about studying prosecution models, policies, and practices in my teaching and in my research. Though much has changed in the operation of county prosecutors' offices, the business model in many state prosecutors' offices remains the same. There's young, inexperienced lawyers who are being hired. They're not making so much money. They're often motivated by law school loan forgiveness programs, and they're hired to do really critical work. I know sometimes I roll my eyes when we prepare them for interviews and they want to talk about the work-life balance. And I can appreciate that. That's young people today. They want a work-life balance, but they're also equally concerned about helping people and not inflicting unnecessary harm on them, and they're not going to tolerate a culture that prioritizes convictions over fairness and justice. So they are going to keep us on our toes. Even the healthiest office cultures can create the abomination or the anomaly of getting it wrong. I use Mark's book, Blind Injustice, as a text in my course. And there's a section there that he references a phenomenon called administrative evil. It's not evil in the sense of the word as we think of evil, but it's consequences of actors in a bureaucracy, and that's what our criminal justice system is. It's a bureaucracy, becoming so tied to the policies and procedures of the system, or the party line, if you will, that as long as they're following procedures and doing what they're told, and everybody else is doing it, then they think they're doing what's right. It's kind of a principle of organizational studies. I don't know what goes wrong in different prosecutors' office and the cultures, but some scholars have considered a phenomenon called the conviction psychology, and it's a confluence of institutional, political, and psychological forces that come together to place convictions as the highest priority of the office. On the institutional level, and this is something that we read about in prosecutors' offices, supervisors are honestly trying to bring out the best in their lawyers. They're trying to help them succeed. And sometimes they do it by publishing their conviction rates, which is like batting averages. Sometimes they put them on a public dashboard so that the citizens can see it, or the other people in the office. In Arapahoe County, Colorado, as recently as 2011, there were bonus incentives paid. And if you tried 5 jury trials in a year and had a conviction rate of 70% or higher, you received a financial bonus. Those who try hard, tough cases or win the unwinnable cases are promoted in the office, and they're praised in the office. And the reason those cases are deemed such is probably because they lack the evidence of a strong case. And so institutionally, we tend to reward prosecutors for winning cases. On the political level, it's very obvious that prosecutors who are tough on crime are appealing to the public more so than prosecutors who promise to be fair and just. It's gotten to the point where a lot of judges are trying to cash in on this tough on crime message, and you'll see this, and certainly on our televisions over the next 12 days, where you don't really know whether judges are running for judge or county sheriff. The high-profile prosecutions that lead to convictions have often led to bigger and better things. For the assistants, they're often elected to be the county prosecutor. For prosecutors, they can be elected to other higher office. Internally, among the individuals, the psychological force is this self-worth that we have. Those of us who've tried cases, there's this quotient of self-worth that you have when you win a trial. Among prosecutors' offices, convictions are coin of the realm. And too often, that becomes melded into the ideology of protecting the public. And that's what drew them to the office in the first place. So they equate the self-worth of winning a trial with protecting the public, and that's why they believe they're doing good. The allure of doing justice, it's vague, it's an abstract. Sometimes it becomes lost. The winning of a conviction is not abstract. It sometimes replaces the idea of doing justice. I wanted to address one very big slice of the criminal justice system, and that is the plea bargaining. Pleas make up the vast majority of the legal system. Many of us equate plea bargains to contract law. In contract law, market forces usually determine each party's risk, and it governs the resolution of a dispute. But once charges are filed, you could look at it as each side has a risk, and so you negotiate a plea to handle the case, to resolve the case. But market forces only work best when the parties are there in equal bargaining positions, and that is obviously not the case in our criminal law. This isn't like a supply and demand issue. When prosecutors are faced with, prosecutors have been asked, what are the reasons you plea bargain cases? And they give a number of them, and economics factors in to some. Victims not wanting to testify factors into others. But the number one choice of all prosecutors in this survey was a weak case is the reason they plea bargain cases. And so when you think about that, if you're using the contract law theory, supply and demand, a weak case is not like a crop that didn't grow. We're talking about truth. And you can't divide truth and parse it out to half truth or a quarter truth and then make a deal based on that. And yet that's what we do. And we do that because we need to get something out of all these cases. And that's something that I really see in the municipal courts that we practice in. is that a case with little evidence or weak evidence is not dismissed. They have to get something out of it, even if it's just court costs. And so when the Chief Justice talked about having courage, it takes a lot to stick your neck out and dismiss a particular case. It's so much easier to use the leverage that prosecutors have to get something out of the case. Unfortunately, this causes people to enter pleas to things that they didn't do. And it really does undermine our system of justice, but there are people in prison on pleas that do not belong there also. And trying to get a plea vacated, at least in Ohio, is like trying to get a horse up a flight of steps backwards. The post-conviction processes here are futile, to say the least. I don't have any individual examples of cause and effect, like we can talk about revamping or improving our eyewitness identification techniques. But I do know that when I came to Case Western Reserve after having left the prosecutor's office, I realized how little we tend to value dissent in law enforcement. And often it is equated with not being on the same team or trying to sabotage a particular policy. But if we had the ability to allow our young prosecutors, and this would be a practice that you would have to develop through their supervisors. You don't want the young prosecutor walking into the elected's office every time they have a complaint. But if we could somehow improve our system by valuing dissent, that would be a step in the right direction. If we could praise dismissals where appropriate, instead of praising convictions and rewarding convictions, that would send that message. If we would give high status to ethics gurus in the office, that would help improve the culture of the office. I don't know how much emphasis we place on Brady versus Maryland, but it would not take much to create Brady panels in the office so that when an issue as to what was exculpatory came up, especially the young prosecutor would be able to talk it through and have a final decision made by somebody who's in authority and who's frankly paid and experienced enough to make those decisions. The internal training on eyewitness identification is something that should be instituted in prosecutors' offices. All of the ideas that come out of this conviction or this summit on wrongful convictions don't fit each and every prosecutor's office. But the idea that somebody had to be bad or evil in order to make this wrongful conviction happen is certainly something that sells well to the media and to the public. And there's a number of people from our community groups here today. And it's not really, for all the time I've put in to the study of these wrongful convictions, it really is a systems failure. And it's very easy to find a scapegoat and blame them and move on and not really worry as to exactly what happened to get it wrong. But it is a systems failure, and we have to have the internal courage to look at ourselves and discuss where we went wrong. And one of the things that I am so proud of is, the only conviction integrity unit in the state of Ohio is Cuyahoga County, and Prosecutor O'Malley has embraced this concept of self-reflection. I'm very proud. It's turned out that some people have been exonerated, but the entire culture that we didn't get it wrong has been removed thanks to the good work of Mark Godsey. And now, when there's a reasonable claim that we may have the wrong guy, I think the county prosecutor is taking the lead and making it that much easier for an individual to be exonerated. And I congratulate you for that, Russ. A lot of that has to do with you. But the culture of the office, like any organization, can sometimes go off the rails, and we need to constantly be checking to make sure that we are truly doing justice and not just getting convictions.
Thank you, Carl. Before we get to Russell, we're going to play one more video. But I just want to comment on something Russell said, that Carmen said. He was talking about when somebody pleads guilty, the chances of reopening that case are like getting a horse to walk backwards up steps. When students in the Innocence Project come to me and they want to talk about a case, I stop them and I say, what are the two questions? Number one, what county is the case from? If I hear Cuyahoga, if I hear Franklin, I go, I'm dealing with some reasonable people. If I hear some other answers, I'm going to filter this completely differently. What I'm about to hear is going to be filtered completely differently. My second question is, they plead guilty or go to trial? Because if they pled guilty, it's virtually impossible. So I'm going to be listening to the information completely differently. So that's totally true. And when you think about 97 or something like that, 96 or 97% of the people have pled guilty, that's that percentage of the people that aren't really going to get my ear very much, because not that I think that they're all guilty, because I know innocent people plead guilty, because the procedures to overturn the convictions are so hard. So let's play the Elizabeth Loftus video on human memory.
There's a common lay belief that memory works like a recording device. You just record the experience and later on you play it back, but that is not the way memory actually works. Memory is actually more of a constructive process. When we remember something, we're actually taking bits and pieces of experience, bringing them together to essentially construct what feels like an actual memory. So I like to say that memory works a little bit more like a Wikipedia page, because you can go in there and edit it, but so can other people. If you ask somebody, how fast were the cars going when they smashed into each other? You're going to get a higher estimate of speed, on the average, than if you ask a question with a more neutral verb like hit. How fast were the cars going when they hit each other? The early questions could affect the answer that people gave to some totally different question that you put to them often much later. So if I ask you how fast were the cars going when they smashed into each other, later on you're more likely to tell me you saw broken glass at the scene, even though there wasn't any broken glass. These leading questions, they contain misleading information that can contaminate a person's memory. We get contaminated when we talk to other witnesses, when we're interrogated in a suggestive or leading manner. We get contaminated if we've seen say a high publicity event and then we see some newspaper or television coverage about that event. All of these situations provide an opportunity for new information to enter a witness's memory and cause a contamination, transformation, distortion, or even just a supplementation of the memory. So what the scientific work on memory distortion is revealing about the nature of memory is that it is malleable. It's not something that's fixed. It's subject to distortion or change or exaggeration, and that's why we talk about the malleable nature of memory. But when it comes to somebody's liberty, even very small errors in memory can make a really big difference about somebody's freedom. So it matters what the color of the jacket of the perpetrator or the facial hair or other things that people are trying to remember when they try to remember a past crime. Many people are just not aware of how many mistakes people can make, and when they are making a mistake and they're testifying, they can often be very detailed and very confident and even emotional in their testimony. We began to study this process, and one of the first studies that I did involved using the power of suggestion to get people to believe and remember when they were 5 or 6 years old, they were lost in a shopping mall with certain family members present in a certain place. And we used suggestive interviewing to plant these memories, and we got about a quarter of otherwise healthy adults to believe and remember all or part of this made-up experience. There is now a string of experiments using this kind of lost in the mall technique where ordinary people have been led to believe that they nearly drowned and had to be rescued by a lifeguard, that they were attacked by a vicious animal, that they committed a crime as a teenager, when none of these things actually happened. And so we now refer to these as rich false memories. You can plant a little seed, and through the power of suggestion, it can grow into something very big and rich and detailed. One of the things that jurors are impressed with when they listen to a witness's testimony, if it's expressed with a lot of confidence, if it's expressed with a lot of detail, if it's expressed with emotion, the jurors tend to believe it more. But what we've shown is that people can be very confident about false memories. People can be detailed about false memories. People can be emotional about false memories. You need independent corroboration to know whether you are dealing with an actual memory or one that is a product of imagination, suggestion, or one of these other processes. We would all benefit if we have a more educated society about the workings of memory, particularly in the criminal justice system. If people are just not quite so willing to embrace and accept uncritically a detailed, confident, emotional memory, but to really ask, exactly how was this sausage made, and not just accept it as being true and authentic just because it's expressed in this way, we'd all be better off.
Just to show how easily memory can be manipulated. One of them, they'll have subjects watch a videotape of a crime where, let's say that the getaway car was clearly blue, and then everyone's interviewed afterwards, and they're asked a bunch of questions, and most people get the car right. They say it was a blue car. And then they come back a week or two later, and they're questioned again, but before they're questioned, they read a police report about the video they had seen before about that crime, and just sort of mentioned in passing, the getaway car is mentioned as white, so a different color. Something as passive as that gets about 40% of the people to then, when they're subsequently interviewed, what color was the getaway car, they answer that it was white. And then they're asked how confident they are, and they tend to be very confident. They're not aware of malleable memory. They're not aware of how that suggestion changed their memory. And we're going to get to the point where eventually we treat human memory like a crime scene. Like right now, if there's a crime scene, you tape it off with yellow tape, and you make sure that the evidence is extracted properly. And the human mind's going to have to be considered that way as well, and so that we're doing the proper techniques to get uncontaminated memories. Russ?
Thank you. Welcome again, everyone, to Cleveland. For those of you who are not from here, traveling grace to you. For a minute there, I love Carmen, but I thought I was on the hot seat for a minute. How many prosecutors we got out in the group? Okay, all right. I think that you all can appreciate whether you're a defense attorney or prosecutor, that this job is not easy. It's not easy at all. And when you talk about the complexities of wrongful convictions, I believe it gets more telling of what we're supposed to do as advocates versus our roles as prosecutors and defense attorneys and judges, for that matter. Because we've seen over and over and over, for those of us who are in trial constantly or have been for years, that things can go wrong. And so when we talk about the subject area of why does wrongful convictions happen, it's a complex question with a complex answer, quite frankly. I love Carmen, And I'll tell you this, he's a zealous advocate, and he believes in his position. And as prosecutors, we do the same. And I don't think that it's a matter of necessarily a competition, but inherently in us as humans. I think that once you get in that courtroom, a prosecutor's obligation goes far and beyond that of a defense attorney. And I don't think that there's not one prosecutor here that would ever do anything deliberately to say that they convicted this person and felt warm and fuzzy knowing that the person was innocent. So I think that it's so complex that when you look at things like jurisdictions who give those bonuses, I can assure you in Cuyahoga County there's no bonuses for convictions. But I can tell you that for every last one of the prosecutors that I know, and I'll be honest with you, I'm very short tenured in the office. As the introduction pronounced, I started out as a young prosecutor for 4.5 years, roughly, in a completely different county than Cuyahoga County. It's called Lake County. Very conservative jurisdiction, but I was proud to be a prosecutor. And I think that all of us in here that are prosecutors are proud to be prosecutors. And you ask yourself, why did you do this job? Why did you take this job? It certainly was not to convict the innocent. And I think that when we talk about issues like eyewitness identification, that's an area that's developing more and more and more, as the chief indicated, that we're changing policies all the time about that. In Ohio, we have a statute 2933, which talks about the blind administration system that Ms. Brown talked about a little bit earlier. And I'm proud to say that we did that. And when I was on the other side for so long and I saw the trend changing and was subject to that, it was very hard to file those motions to suppress the eyewitness identification when they're doing it in such a way that's more reliable. And I think that we could applaud ourselves here in Ohio that we're trying to do things that change the culture. But inside the prosecutor's office sometimes, I saw it 20-something years ago and I see it today sometimes, that we have what's called, we focus in on our case, we zero in on a theory, and people call it tunnel vision, but I call it passion for victims, and I call it, we got the investigation from the police department, the best that we could do, and we went forward. But sometimes, and the supervisors that are in this room can attest to this, when we change our policies and practices because we don't want to, thank God there is change, because we don't want to do what we always been doing and get the same result. So as supervisors, we constantly, from grand jury and sometimes pre-grand jury, will bring the younger APAs in and go through their cases with them. It's called a docket review. And all the time, my co-criminal chief, Diane Russell, was in the back there, has helped me with this new process of being a prosecutor again. But what we do a lot of times, we are approached constantly, and we're making it more of a practice and policy statement to stop why these wrongful convictions occur. And we, just the other day, we dismissed a case, and thank God, 1 week later, let the guy out of jail. 1 week later, the real perpetrators in Cleveland.com, because we knew something was wrong. We knew it. And I think that conviction integrity means that you don't just look at it from the back end, you look at it from the front end, and you try to start from the moment that a case is indicted or before. Because Sal Awadallah, who you heard earlier that introduced Mr. Jackson, what a compelling story that he has. But what we often do in the major trial unit, we'll bring them together, and sometimes he's like a drill sergeant, and then they'll come to me and whine a little bit, And then they'll go back to Sal because I'll say, no, we're trying to teach these young prosecutors, it's not about wins and losses. It's about justice. So when you say why wrongful convictions occur, to me is very, very, very complex. I had a case recently that we dismissed, a very serious case, a rape case. And I think about when I was pondering the question that Mark asked us to talk about, is why do wrongful convictions occur? You know, I got a email, of all things, where the defense attorney, of all people, was complaining that we had dismissed a rape case. And it bothered me immensely, and we talked about it and we tabled things, because what we try to do, and I'm sure offices across the country in this new culture of criminal justice reform and getting it right the first time, try to table things and not have this tunnel vision where it's all about, we got the case, we got the suspect, that's it. Oftentimes we make our detectives, begrudgingly sometimes, candidly speaking, go back out and interview this witness. Go back out and get this evidence and get it to our medical examiner. And to me, that's the broad concept of conviction integrity. And Mark wanted me to speak a little bit about the unit, but I'd rather speak a little bit more about some of the points that was made up here. And then I'll talk briefly, because I don't really like talking about, the unit. But coming from a defense background after being a young prosecutor has really equipped me to look at things differently. And I believe that we try to scrutinize more under Mr. O'Malley as my boss and our county prosecutor. We try to get things as soon as we get it and we hear about it, we deal with it. And thank God for Christian Sobieski, who is here from our appellate unit. Our appellate unit, and all appellate units for that matter, have a completely different role from conviction integrity units. And I think the one thing that we got to appreciate is, and we're thankful and blessed to have, is that Christian thinks out of the box. Her goal is not simply to protect the conviction. She's looking at it from a standpoint of, yes, I'm a protect the conviction only if we feel the conviction is right. Now, sometimes that may be opposite of the way that I'm looking at things. And I may look at things like, well, wait a minute. Let me look at this. What about this witness? Let's go interview this witness. So sometimes we're on the same, two different tracks trying to get to the same goal, and that's to get it right, post-conviction. So I guess when I sit up here again, when I think about why does wrongful convictions occur, I have to admittedly talk about defense attorneys as well. Because defense attorneys sometimes, they mean well. I was one for many years and very proud of it. Sometimes you get so bogged down that you're not challenging the prosecutor. You're not filing the motions. You're not following up sometimes. And I'm not talking about any defense attorneys in this room in particular. What I'm talking about is in generalities, because sometimes it's really questionable, and I'm scratching my head on why is it that you're not objecting to certain evidence coming in, okay? And I say that both as a prosecutor and a former defense attorney, because the judge sometimes needs to be educated. So I don't want to exclude the court out of this, because we need the court. We need the court to be the referee. We need the court to make sure that the advocacy process is not too derailed. But when I hear stories like Ricky Jackson, it reminds me why we should all work together. And I believe that having conviction integrity units across the country is growing. I'm glad to see that I believe, and correct me if I'm wrong, I'm sure my next panel will correct me, I believe we're up to about 35 or 6 units now as of the beginning of October. I know Florida just got a unit. Tennessee is not, just got a unit about a year and a half ago. And so we got units and we're working together, and I love this seminar because we're working as partners. This is the first time that we were able to achieve a summit and conference in Ohio where the Innocence Project and the Prosecutor's Office came together for a common goal of wrongful convictions. And I think that that's something special. You know, as I practiced on the other side for so long, I didn't think I'd ever see that, quite frankly. So wrapping up, I just want to say that I do take a little small exception to what Carmen said about pleas and plea bargaining. I don't think that's why wrongful convictions occur. I don't think that's one of the reasons necessarily. And if it is, I think it's incumbent upon us as prosecutors to orchestrate these criminal review units or conviction integrity units and look at some of those cases. You know, there was a time when in our office that we would not look at, if you pled guilty to an offense, you were not allowed any conviction integrity review, quite frankly. We changed that. Mr. Jose Torres, my coordinator, is here and was able to get out of court and get here, and thank you for coming. He and I have worked diligently trying to make sure that we make our policies more broadened. And the same thing goes with our APAs. Our supervisors that are here are constantly in meetings and doing docket reviews to try to stop these things and these wrongful convictions, because these are real people with real lives, with real families. And then we have, on the other hand, victims who are either mistaken or for whatever reason, they're re-victimized again. And so we're dealing with that, and we're going to talk about that on our next panel. I'm so glad to see that everyone made it, and that we got a broad spectrum of criminal conviction integrity units and prosecutors here today for your pleasure. Let me wrap up by saying this. Having a weak case does, in fact, have some bearing on why you plea and negotiate and resolve a case. But I think it's such a small percentage, and I don't have any data to back this up, because most cases in our criminal justice system, I believe Ms. Brown mentioned this, result in pleas. That's just the way that it is. It's a way to resolve a case and not to spare both the defendant and the victim, for that matter, from going through a trial, period. And I'd like to say that in this process, it's never going to be perfect, but if we keep doing collaborative efforts like this, we can continue to reach that goal of perfection. Thank you.
Thank you. So now we can take questions from the audience for any of the panelists.
Do you want to go help him? Or
Yeah.
All right, good, that's working. Hey, so Rebecca, question for you. What are some of the legislative reforms that you're working on now?
Sure. So we're continuing to focus on eyewitness identification reform. We're working on the recording of custodial interrogations. We're working on tracking and regulating the use of jailhouse informants. We're working on discovery reform quite a bit. In our home state of New York, we have some of the worst discovery rules in the country, not like here in Ohio. We don't get police reports, witness names, or witness statements until the eve of trial. So it's really, in many ways, trial by ambush in New York. So that's a legislative effort that we're working on in New York State. We're working quite a bit on compensating the wrongfully convicted around the country. Only 33 states even have laws compensating the wrongfully convicted, and many of them are pretty limited in substance and scope, so that's been a big focus. We're working on state-based forensic science commissions so that there's sort of a non-blaming look at sort of different forensic disciplines. The gold standard is in Texas, just an excellent forensic science commission. And then we're working on different ways of revealing wrongful conviction. So all 50 states now have laws that provide statutory access to post-conviction DNA testing. Some of them are limited in substance and scope. For instance, in Kentucky, if you did plead guilty to a crime you didn't commit, there's no access to DNA testing.
Same with Ohio.
And same with Ohio. State of Alabama, you can only get DNA testing if you were charged with a capital offense. So, certain states were really trying to, bring those old laws into the 21st century. And then we're working on in a new area to provide statutory access to the courts or create a statutory mechanism when science changes or evolves or when experts repudiate past testimony. A lot of the time people are time barred from being able to get back into court and show that science has changed. And so those are just some of the efforts. We're thrilled that, in the last 3 years, 5 states have moved in that direction. California, Texas, Wyoming, Connecticut, and Michigan all created these mechanisms. So there's a lot of movement afoot, but those are the core reforms that we've been working on.
I'm not sure who I want to direct this to, but how do we take money out of the equation? So I think the public doesn't want to give millions of dollars or take it away from a particular budget from the county all of a sudden. You take a hit when you have one of these things. So, and the prosecutor's office, of course, doesn't want, you have some obligation in order to make sure that people are treated fairly. So I think I'd like to hear more, maybe other people would too, about that type of legislative change. What is an appropriate amount of money in a pool in these other states, and what have they determined takes care of these things? So you'd at least take that out of the calculus, or the appearance of that out of the calculus. And Mark, maybe you or the others would know a little bit more about this.
Yeah, I mean, the numbers, probably Rebecca knows better. It's something like 30 states have compensation statute, is that correct?
Right, 33 states have something. The federal statute is about $50,000 per year, which passed now over a decade ago. So we've sort of used the federal standard as as the minimum, which is about, and adjusted for inflation, which is about $64,000 per year in today's terms. Texas, again, has the gold standard law on compensation. They provide $80,000 per year with an annuity valued at the same. And what's great about that law, I mean, it's an excellent law. It also contemplates social services, reentry, like long-term social services. So it's a very strong law.
I think it's free college, right?
Free college.
State institutions.
Yep. Kansas also just passed an
Texas,
excellent law just last year. It's a very good model to look at. To answer your question about sort of who's paying, how does this work? I mean, I think the value of having a global compensation statute is that when a global compensation statute exists, people are less likely to pursue civil litigation, which is actually a very, protracted form of litigation. It's very, difficult to proceed with that. And frankly, obviously, you have to prove official misconduct that led to a constitutional violation. If somebody can't do that because there was no fault at all, and often that is the case, and there's no global compensation framework, they don't get anything. And so, I think the goal really is to have a fair and global framework that can be applied evenly. We still have 17 states that need to pass these laws, and many of the existing laws really have to improve.
More questions? Going once, going twice? Okay, well,
There's one.
I'm sorry.
You'll wait?
afternoon. I'm Celeste Hart, and I write for African American newspapers. I'm not covering this event. But now, he said, how you take money out of the equation? How you take race out of the equation? And let me tell you, I am from Cleveland, but I live in Charlotte. We were so glad when African American had the wrongful conviction review. You know, we finally got somebody we think is going to be on our side, because 65% exonerations are African Americans, minorities, not just poor. All right, so how do we take race out of the eviction, and are you looking at that in a particular way because you are African American? So do you take that into consideration at all?
I'm assuming you're talking to me, right? That's a very difficult question. I think we could have 3 days on just how race is impacted in some of these cases, and I think the numbers are pretty clear. Rebecca could probably address that more so. That's more of a systemic problem with the system, more so to speak. When I look at a review of a petition in our unit, I'm looking at everything. Okay, I'm not really looking at, who the person is, what kind of crime they committed, this, that, and the other. I'm not going to give more weight because it's a murder case versus we had one that was a measly F5, okay? Because it's still real people with real lives. And so I am cognizant of all factors when I'm looking at petitions, and I think that's the only way to do it. I have to be colorblind in the sense that, everybody who's petitioning deserves a shot, deserves to be looked at as long as you meet the initial criteria. So I'm not looking at it from the standpoint of race, so to speak. I'm looking at it from a standpoint of fairness and whether or not this petition, and they have a valid claim of either actual innocence or a compelling claim.
I guess I just have a quick comment to Carmen and Russ. I'm Britt Newman. I'm a solo defense attorney, so I take both assigned and retained clients. And Mark, something you mentioned made me want to, mention something. The calculation you said when people that you supervise come to you about a new case. So when a potential retained client comes to me, kind of the first question I tend to ask, and for the most part, it's in the JC. It's usually a felony case, as I find in my practice. And so, of course, the first question is, who's your judge? And then the next question is, that I got to find out is who's their prosecutor and who's their supervisor. And unfortunately, I feel that it tends to come into the calculation for how is my position going to land? How much work am I going to have to put into this just to be listened to? So I think that maybe your positions could be a little more dovetailed, because I've already seen, maybe you guys aren't so different, as you thought you were, because I have seen through you and also Rich, because I had the pleasure of being able to start a relationship with you guys when you were on the other side. I've, worked with you, I've worked with Jose, and then I've worked with Rich, and I feel differently kind of walking into your guys' office or, going past, the floor prosecutors that I tend to work with most of all. So I guess I just wanted to say thanks. You guys aren't so different. You were respectfully disagreeing, and I just wanted to say I think that plea process is, I think you made a great point. You guys all made great points, and I think we're starting to see that. Am I making any sense?
Yes.
Yeah.
Yes. Indeed. Can I just make another comment? I don't know what Cuyahoga County's plea process is, because I don't do felony cases in Cuyahoga County. But in the research, we find that among the other policies in different jurisdictions, some prosecutors put time limits on pleas so that a defendant must enter a plea by a particular date or time. Some prosecutors force defendants to withdraw all motions in order to plead. Some won't take no contest pleas without other circumstances, and some don't even deliver Brady material at the plea bargain stage because, and the federal courts support this. The courts are complicit in all this, by the way, but the Brady issue is a trial issue, and some courts hold it's not a pretrial issue. So there's a lot of things that go into a plea that the leverage is uneven as it begins, And there's a lot of things that go into the plea bargaining context that sometimes we don't do justice. And I certainly didn't mean Cuyahoga County, because I don't know what they do in Cuyahoga County.
And I would just say that in response to your comments and question, the bottom line is for us, I think that Carmen's absolutely right. I told you earlier that I came from a very conservative jurisdiction 20-something years ago. Things were different there, than it is here in Cuyahoga County. One thing I can say back then, they had open discovery. But the plea negotiation was totally different. You can go up to Lorraine, for example, which is a county just not too far from here, maybe 40 minutes for those out-of-towners. And your plea bargain is plead to the indictment and get your justice or mitigation with the judge. And, so you may not be as comfortable going out there pleading to the indictment. What did you really do for your client? Your arguments with the judge. So I think Carmen's exactly right. Every jurisdiction is different how they deal with plea bargaining and trial schedules. For example, in a lot of counties outside of Cuyahoga County, you get a trial date certain, you're going to trial. In Cuyahoga, it's up in the air. There's so many judges, there's 34 common pleas judges that we contend with every day with 34 different personalities. So the plea bargaining process is so different. Some of those judges within Cuyahoga County have their own rules, and you got to abide by them. And we respect that. I think both sides have now come accustomed to some of the more rigid rules that we have to deal with, which that as a professional, you're going to deal with it and meet those timelines, whether you think it's fair or not. So I do. Carmen's exactly right. The research is right on in that respect. It's just that we do things a little bit different.
Hi, thank you all very much. This has been very enlightening. And my specific question is for Russ, based on a comment you just made. You said a measly F5. Mm-hmm. And I am a city prosecutor in Cleveland, so all I deal with are misdemeanors. Mm-hmm. However, I feel like making sure that prosecution of misdemeanors is just as important to be thorough as prosecutions of felonies, because although measly F5s or measly misdemeanors might not seem like that much in comparison to something like what Mr. Jackson dealt with, it still can affect someone's life.
I absolutely agree with you. I absolutely agree. And if I said that in a bad tone, I didn't mean it that way. I think that and in fact, I've invited several of the city prosecutors here.
I know, thank you.
Because my goal is to hopefully, if we could, establish CIU units in city prosecutors' offices as well. Because I think that just because it's a traffic offense or misdemeanor or what I said earlier, measly F5 in comparison, doesn't mean that a wrongful conviction cannot occur. So I absolutely agree with you. If I said that, I do apologize if I said I didn't mean it in a bad way. Okay?
Any other questions?
I have a quick question about the videos. My conviction integrity unit is dual purpose. We're reactive and proactive. And so are the videos going to be available for us to incorporate them into proactive training for our prosecutors?
Absolutely. They're going to be publicly available, totally free.
We'll be doing press releases in probably 2 weeks, right?
A couple of weeks. We're finalizing everything. We want to make sure we want to do the rollout together collaboratively with the IACP. And as soon as they're ready, they'll be available to everyone. And we'll somehow figure out how to get them to you.
Yeah, is it going to be like on YouTube or
Yeah.
library, an Innocence Project library that we have to have?
We're going to put them probably on a landing page on our website. And then in addition, I think you will and
the IACP website.
will.
They're going to be landing places on all three.
Yep.
And I know on ours we're getting closed caption as well, so there'll be an option.
Great, sure.